Okay, we're going to get started because it's just a little afternoon right now. I know Judge Delano has an afternoon docket that I'm sure she wants to be ready for. So today we have Judge Delano speaking about some issues in Chapter 11 that she requested time to speak about. So she'll be speaking about that in a little bit. I do have a CLE credit for this. If you guys want to take the course number down, you can apply for it on the Florida Bar. And it's 130-731-8, N as in Nora. Anyone else need that number again? Okay. That will probably be posted along with the video online if you need it again. Additionally, we had some issues with the listserv that we discovered during the dinner emails and whatnot, so I printed out a copy of the listserv. I'm going to put that around. Make sure your email is correct on it. If you want a different email listed, cross it out, put the email you want to get notice of bankruptcy bar issues on it. Listservs have limits on how many emails you can have on a listserv, so I don't want to have multiple emails for one person. So just pick the one that you want and put it on here. If you see somebody that's email is incorrect or that you think would want to be on the list that's not on the list, go ahead and write it down and I'll add them to it. So I'll put that around to flow through the room as Judge Delano is presenting. I know some people have requested to make some announcements, so anyone, Diane, you said you had an announcement to make?
For any of you who knew him, I just wanted to let you know that Ron Stetler died, who was an attorney in Collier County, used to do debtor work and creditor work in like the 70s, 80s, and maybe 90s. But he was a delightful gentleman. It was quite surprising. He's only 61, so I'm very sensitive.
Anyone else have any announcements or any issues they'd like to bring up? Okay, without further ado, Judge needs no introduction. Judge Delano.
Okay, we've been working on technical issues here, and it sounds like they're solved. Oh, great, wonderful. And then, do I use some mouse if I can say?
Yes.
Right.
Sorry about that.
That's okay. No problem. Okay, perfect. Okay.
Thank you, Jeff.
Okay, thank you. Before I get started, I wanted to just make a couple of general announcements. First of all, you probably received a blast email yesterday or this morning about the revised negative notice list. So sooner or later, everything's going to be on negative low notice, but it's taking a while to, drag 8 other judges, not me dragging our chief judge, Judge Gentleman, dragging 8 judges all in the same place at the same time. But that should be coming, I think within a couple of years, we'll be doing everything on negative notice. The most recent addition to the negative notice list is final fee applications in Chapter 11 cases. And one of the things that's pointed out on the negative notice list is that you need to include the summary sheet on your fee applications. This is posted on the court's website under forms, under miscellaneous forms. So make sure when you're filing fee applications that you include this form. What it does is basically summarize what's in the current fee application as well as prior fee applications and the amounts awarded so that the court knows what the total amount of the fee applications are. Another announcement, View from the Bench coming up in Tampa, November 7th in Tampa, November 8th in Miami. I hope some of you will consider coming up to Tampa for it. When I was a lawyer, I liked View from the Bench of most of any CLE that I went to. You get 4 hours CLE credit, and it's an easy way to get 4 hours credit. It's really entertaining and informative to see the judges in kind of a relaxed, informal setting, just talking about cases and things along those lines. So Robbie Colton is the moderator this year. Robbie always sings. It's always entertaining. It's worth being there.
She's not sure she's singing this year.
Huh?
She said she wasn't sure.
I saw a song in there. I saw a song in there.
Okay, she's modified.
That's right. The other thing is that the night before the Tampa View from the Bench, there is a reception at the Tampa Club. No, actually it's at the University Club this year. They are charging separately for it. But that's always a fun reception too, and I'd urge any of you that are thinking about coming up to Tampa and maybe spending the night, because it's an early morning. I think we start at 8:30 in the morning. But I would encourage you to come for the reception. And in addition to the usual, fun that's had at the reception, there is going to be something special that happens this year, which is this. I don't know if you're aware of this. I wasn't until I was on the bench. But when a judge passes away, the 11th Circuit does a proclamation, and it is a beautiful calligraphy proclamation. It's framed, it's absolutely huge. And that was delivered to Judge Gentleman a few months ago by the 11th Circuit, and we're going to be presenting that proclamation in honor of Judge Pasquet to Mrs. Pasquet at the reception. So that is again on November the 6th, the night before the view from the bench. Another thing I just like to mention, this is National Pro Bono Week, and I am telling you, I am just so in awe of the way that the lawyers in this community step up to help pro se parties when they come to court and just don't really know which way to go, and they seem like they're kind of helpless. And there's a group, a core group, that is always willing to stand up and assist somebody. And you know, sometimes it might just take 5 minutes of explaining to somebody what's going on. Sometimes I know they end up with a more formal attorney-client relationship. One thing that I thought you might want to think about as a group, possibly, and that is in Tampa and Orlando now, they have regular hours when pro ses are given the opportunity to see an attorney and talk to an attorney, and so it's staffed by attorneys in the community. And it's a little more difficult in Orlando now, where they have 3 judges. In Tampa, where really 3, I guess you could count me, but I'm not seeing too many pro ses in Tampa now. But because the judges have different calendars, so it's hard to get with a time that it makes sense to do that. But it does seem to me that the way our calendars are set up, it really is almost a perfect environment to say, well, on Wednesdays, which is the Chapter 7 calendar, or no, Thursdays, which is the Chapter 7 calendar morning, to have an attorney that's just available, where I could send people out in the hall if they needed to consult with an attorney. So both Thursdays in the morning and then in the afternoon for the Chapter 13s. And you know, one lawyer could just sign up to do the morning, one lawyer could sign up to do the afternoon, and maybe just be available for about an hour in the morning or the afternoon. So that's just something to float out to you all to think about. Maybe that's something that would work. Possibly the informal system that you all are working with now is working out, and that we don't really need to make any changes, but I just thought I would float that out there. So, on to Chapter 11. Chapter 11 is really, some people might think, the most interesting chapter of the Bankruptcy Code. It certainly can be the most challenging from an attorney's perspective, from a client's perspective, and certainly from a judge's perspective. And I thought after, now that I've been hearing cases here for a little over a year, I thought probably would be helpful to walk through what I consider to be some of the best practices in Chapter 11 cases, things that I've seen that have worked, things that I've seen that haven't worked, just so that you all know what I'm expecting. So this is a pretty basic little summary. There certainly are seminars out there that will go into much more detail in Chapter 7 issues, but I just wanted to kind of touch with a broad brush the areas that I think counsel need to pay attention to. The first couple slides here, just make sure I know how to do this now. Okay, not working. Jeff? If you could help, please. All right, I clicked, it didn't click. On. Okay, well, I can do this without the slides. Do all of you, I know that the printout was emailed to you yesterday or today, and if any of you don't have a copy, there's extra copies up here. So we don't need to do this from the big slides. It's just not quite as fun to do a PowerPoint when you don't have the projection screen behind you. But the first few slides I borrowed from Judge Williamson. Judge Williamson has a presentation. It's called Can This Dog Hunt? And it's basically an analysis for attorneys to consider when they're talking to their clients and trying to make a decision whether it makes sense to file a Chapter 11 for a business. So Judge Williamson identified a number of areas that the attorney has to be aware of. First is the type of debtor. Second is the type of the problem, the financial structure of the debtor's objectives, and also possible alternatives to Chapter 11. So first comes the type of debtor. And you think about the range of Chapter 11 debtors that you see in this court. Possibilities, and these are just the ones that they were on the screen, you would see them: hotel, automaker. I haven't had an automakers bankruptcy yet, maybe you will. Retail chain, home builder, trucking company. Certain types of businesses are amenable to Chapter 11s, and other types of businesses just aren't amenable to Chapter 11. And you might want to give that, oh good, working? Okay. Okay, great. Let me just, okay. Am I gonna click with, there we go. Perfect, great. Thank you so much, Jeff. Certain types of businesses just don't work in the Chapter 11 environment. And I will tell you from my experience as an attorney and also as a judge, the one industry that is very, very difficult in a Chapter 11 is anything related to the construction industry. First of all, the construction industry doesn't think much of the automatic stay. So you may have construction trailers on site, and your debtor may wake up one morning and they will be gone, and that makes it really tough. The other problem with construction-related debtors is that those type of businesses depend upon work in the pipeline. They're finishing up jobs, they're getting new jobs. They're finishing up jobs, they're getting new jobs. As soon as you file a Chapter 11 for a business that's in the construction industry, that pipeline stops because no one wants to do business with a construction company that's in a bankruptcy proceeding. The worst case, I like to say the worst possible debtor you can have is a swimming pool contractor, okay? And I've built a couple swimming pools, and every time I finished, I was like, oh, thank you, Lord, I'm not left with a hole in my backyard. Because you read these, you hear these stories on the news all the time about people that are left with holes filling up with rainwater in their backyard. But if a swimming pool contractor files bankruptcy, every homeowner that's working with that contractor is trying to figure out where they are in the project and getting somebody else to finish it up. So that's really a tough one. Restaurants probably doesn't make that much of a difference. Retail stores probably doesn't make that much of a difference. But if you're in an industry where someone needs to know that you're going to finish the job that you've taken on, it's a very difficult industry to succeed in a Chapter 11 case. The next thing that you have to take a look at is the type of the problem that the debtor is experiencing. And a lot of times, a bankruptcy case is prompted because of a disaster that's hit a company. And when it's a disaster that's hit a company, the company can frequently move on from that disaster. So for example, a one-time catastrophic loss. That's something like the BP oil spill, something like Hurricane Charlie, comes in, destroys businesses, destroys cash flow. And if it was a good, solid business to begin with, it's likely to be a good, solid business again. That debtor just needs to get over the hump of its financial difficulties. Sometimes a bankruptcy is caused, or financial problems are caused by unprofitable locations or product lines. I had a case once in Tampa. It was a company that made bundt cakes. Who would think that a bundt cake baker would have 3 factories, Florida, Alabama, and Oklahoma? They found out they really needed to close 2 of those, and they sold 2 of the plant locations. I didn't know that a food maker was called a plant, but they are. Anyway, so they were manufacturing bundt cakes. So, sometimes a company just has to look at what its business is and decide what's profitable and what's not profitable. Too rapid expansion, that happens a lot of times where a business will open up branch locations or just expand. They take on a lot of debt. The business isn't keeping up with servicing the debt, and so they need to make some changes. Competition, that's a tough one. If your client is not doing well in a business environment now because of competition, how is a Chapter 11 going to help that business? The competition's still going to be there. So competition, that's a business problem. That's something that you probably can't solve in a Chapter 11 case. Too much secured debt, again, that probably depends upon the case, depends upon what the secured debt is for, depends upon whether the client is underwater or has equity in property that is serving as collateral for secured debt. But that's probably something that can get handled in a Chapter 11. And then poor management and lack of financial controls. That's a tough one. It's very difficult to say to the client that's sitting in your office, well, the problem is you're not doing a good job. Because the client that's sitting in your office is there because he or she wants to preserve that business. They want the income stream from that business. Jerry McHale can probably tell us about a lot of businesses that suffer from poor management and lack of financial controls. One of the problems, and this kind of can go back to the one-time catastrophic loss issue, one problem that sometimes hits a company, they find out they had a lack of financial controls when they find out that the bookkeeper, embezzled hundreds of thousands of dollars. Well, that's a catastrophic loss that they can get past, and maybe they need to put some internal financial controls in place so that that doesn't happen again. The management is a tougher issue, especially with a family-owned business. Sometimes you'll see a family-owned business where there's 10 or 15 or more family members employed. They all just grew up and thought they'd go work for the family business, and it worked fine when it was their grandfather's business, and it worked fine when the grandfather passed that business on to his 4 children. And by the time that business is passed on to 20 grandchildren, it's not working quite so well. So you do need to identify the problem and see if it's something that can be overcome. Next is, or are, come on. This is a strange computer. And now that my IT person has left, it is not working. Okay. Next is, the debtor's objectives. And when you say the debtor's objectives, generally speaking, you're talking about the principal's objectives for the debtor. And you have to keep in mind, of course, oh look, it worked now. You have to keep in mind that the debtor's principals frequently are interested in maintaining the business for their own benefit. You also have to remember that when you sign on a corporate client, your obligation is to the corporate client, it's not to the principals. There are times when you want to refer the principals to independent counsel so they have a source of legal advice that doesn't include you, because your duty is to your client, the corporation. So you have to keep that in mind. As a practical matter, when the president and sole shareholder of the corporation is sitting in your office, that person is interested in what's best for him or her. So that's something that obviously you need to explore. Sometimes the objective is to maximize liquidation value. And that would be primarily when the principals have personal guarantees. Sometimes the business is failing, they know it's failing, they need to get out of it, but they personally guaranteed the bank for hundreds of thousands, if not millions of dollars. They want to maximize the value of the collateral so that the bank gets paid as much as possible, reducing their exposure on their personal guarantees. And if the company's assets are threatened with foreclosure or repossession, that's not going to maximize the value of the company. So that is certainly a legitimate goal to a Chapter 11 case. Sometimes the debtor's primary goal is just to save the business. Current ownership wants to continue to own the business and enjoy the income stream, and many times their current ownership really does want to preserve jobs for employees. Sometimes that can be accomplished even if the company's sold. I mean, just because the business is preserved doesn't mean it's preserved for the same ownership. Sometimes the business, the assets are sold to a third party. Sometimes the insiders end up with jobs working for the third party. So that's something that can be accomplished as well. There are alternatives to Chapter 11s. Let's see. I think this just has a lag time, so maybe it'll... Oh, look, it came. There are alternatives to Chapter 11 cases. One is a friendly repossession. That's where you're in communication with the bank. I had a case once years ago while I was still practicing, a client that owned a chain of lighting stores and had overexpanded, and they were taking huge salaries while the business was good, and then when the economy started to sour, 2006 and 2007, it was not good. And it was a sad day when I had to call the Bank of Tampa and tell the Bank of Tampa they were not going to get any more money. They were surprised. They thought they had a very good relationship with the borrower. And we worked out a series of liquidation sales trying to maximize the value, but sometimes that can be worked out. You're all probably familiar with ABCs, assignments for the benefit of creditors. Those have advantages, particularly if you have a buyer waiting in the wings. What I always like to tell clients when I was handling Chapter 11 cases and debtor cases as an attorney, was that the advantage to a bankruptcy is you draw a line in the sand, and all the bad stuff is on one side, and then the debtor is free, or the owner of the company is free to go on with the good stuff on the other side of that line in the sand. And what you don't want is you don't want the bad stuff to trickle over into the good stuff that's happening. So that's an advantage sometimes to filing an assignment for the benefit of creditors, especially if you have a buyer in the wings. Before we started today, Diane was saying that Judge Pasquet said it was malpractice to file a Chapter 7 for a business. Okay, Chapter 7 trustees, close your ears. You don't want to hear this. Man, do not file a Chapter 7 for a business. It's a disaster. Chapter 7 bankruptcy trustee starts looking at a magnifying glass over, I mean, it's a disaster for the principals, maybe not for the creditors, but starts looking with a magnifying glass at every transaction that debtor has had with its principals. And the principal that came in to see you, what am I going to do? The bankruptcy, the company is in, terrible financial stress. I've got to just put an end to it. Let me pull the plug on this company. And the next thing you know, they're the target of preferential payment litigation, target of fraudulent transfer litigation. Their family members are being sued. Oh, it's very difficult. So I would look very carefully at a company's books and records before I ever advised a corporation to file a Chapter 7 case. The advantage to filing the Chapter 7 case is that the lawsuits against the company stop, and in theory,
cheaper way to liquidate if you have a bunch of stuff and have the trustee go do it, and there's been no business operation.
It can be. That might be an advantage. And how many cases have you done that in? 2? How many years have you been practicing?
31.
31? Okay, so once every 15 years, you may have a case that it really works out to file a Chapter 7 for. But, I think that's just something you have to tread very carefully with, because it can just be a problem. Another alternative is to sell a business. Sometimes a debtor is able, if there's not a threatened foreclosure or a threatened repossession, the debtor is able to just negotiate an arm's length transaction. And of course, there's out-of-court workouts. I don't see the out-of-court workouts anymore. So I hope that you all are working things out of court and getting things worked out and getting things resolved. Sometimes banks are willing to negotiate on personal guarantees if they see a lot of cooperation and they see certified financial statements for the insiders, things along those lines. Sometimes you can work things out. Okay. Part of what I wanted to do, there is just a time lag here. It's not interesting. Part of what I really wanted to talk about today was the mechanics of a Chapter 11 case. And this may be familiar to most of you, and I hope that as I go through this, you maybe pick up something that's a little bit new. But the first thing that I want to point out is we have this incredible local rule, which is Local Rule 2081-1. And every Chapter 11 practitioner should have this printed out and sitting on his or her desk and be looking at it during the course of the Chapter 11 case, because it is really a roadmap on how to handle a Chapter 11 case from day one. It is just an incredibly valuable local rule. So I strongly recommend print it out and keep it on your desk. One of the first requirements we have in Chapter 11 cases is that the debtor file a case management summary. Now, a case management summary is essentially a snapshot of the debtor's business operations, what their assets are, what their debts are, what type of a business it was, who their principals are, what kind of salaries were being paid. It's just a good snapshot. And the reason why we need that snapshot is a couple of reasons. One is because debtors, Chapter 11 debtors frequently file without filing their schedules. So this snapshot tells the judge from the very beginning of the case what's going on. So that's the first reason. The second reason is even if the debtor has filed schedules, there is some information in the case management summary that's helpful. First of all, it's a summary of the schedules, so the judge doesn't have to page all the way through the schedules. That's number one. Number two, the schedules don't tell you why the debtor filed a Chapter 11. They don't tell you what the debtor hopes to accomplish in a Chapter 11. So it gives some basic information that the court is very interested in. Our rule for the case management summary is that it's supposed to be filed within the earlier of 3 business days following the petition date, or the day on which the debtor in possession first files a motion requesting affirmative relief. So If you're going to be filing a cash collateral motion, file your case management summary first. If you're going to be filing a DIP financing motion, file your cash collateral motion first. The judges are pretty much agreed, and I have to say there might be the occasional exception, but pretty much we've agreed. We're not setting hearings on emergency motions until we see that case management summary. That's the one way of enforcing that requirement. Sometimes an attorney will file a motion for an extension of time to file the case management summary because the attorney says that he or she doesn't have enough information to file it. When I see that, I am frightened, because if you don't have enough information to prepare a case management summary, you really didn't have enough information to file the bankruptcy case. Now, if there was a foreclosure sale scheduled for tomorrow morning and you filed the bankruptcy case at midnight, fine. But you may have started something that you didn't want to start. And every once in a while, you'll see debtors in Chapter 11. They're like, deer in the headlights, and they don't really understand what they've gotten themselves into. And the one piece of advice that you really need to give a prospective Chapter 11 debtor is that the case may go south. And if it goes south, the case may be converted to a Chapter 7. You're not in control of your own destiny. The way a Chapter 13 debtor can always get out of Chapter 13 if the Chapter 13 debtor needs to. But a Chapter 11 debtor might find himself or herself or itself in there for the duration and might find the case converted. So it's very important to know what it is your client is getting into when your client files a bankruptcy. But more important, it's much more important that your client know what your client's getting into. So again, the case management summary, I can't emphasize the importance. Okay, other first day motions include cash collateral, DIP financing, pre-petition wages, critical vendor motions, affiliate officer salaries, and utility motions. Let's see, this is going to move slow there. Okay, good. I just wanted to mention that most of those motions are usually filed on an emergency basis. And we do have a requirement that every emergency motion be accompanied by a certificate of emergency. And I thought I brought a copy of one with me, but I think I didn't. The certificate of emergency form is on the court's website under miscellaneous forms. The judges agreed on a new form of certificate of emergency a couple of years ago, maybe 2 years ago or so. And the form now, in addition to saying I'm filing this, knowing about potential ramifications of Rule 9011, now in addition to that statement, you also have to set forth the reason for the emergency and the date by which you need to have the hearing held. For example, if payroll is Friday and you filed your bankruptcy case on Wednesday and you want to pay pre-petition wages, you need a cash collateral motion right away, and you need a motion to pay pre-petition wages right away. So you need to tell the court that the payroll date, pay date, is Friday. If the pay date is the following Friday, there might be a little bit more time in there. And I have to laugh because sometimes I see the reasons that are stated on a certificate of emergency. I got one from a very prominent Tampa firm recently, and it said, we need an emergency hearing because blah, blah, blah. We filed an emergency motion. Really? Really? So you have to think about that. And, you're doing that for a couple of reasons. One is because judges are busy. They need to schedule these hearings, among other hearings. We have a lot of obligations I had no idea judges had before I went on the bench. But, oh my gosh, there's meetings, there's conferences, there's all sorts of things. And we don't want to have your emergency deadline come and go just because it wasn't convenient for us to hear a case. And even if I'm out of town or one of my colleagues is out of town, we'll cover for each other. If it's a real emergency, you just put the date in the certificate of emergency by which you need to have the motion heard. Also a great idea, you file a certificate of emergency, call the case manager, call the judge's courtroom deputy, alert them. We have a process by which these motions get brought to chamber's attention pretty quickly, but you don't want to slip through the cracks. And if you file an emergency motion without filing a certificate of emergency, not handled on an emergency basis, so you've got to file that. David, you had something?
Yeah, we include our certificate of necessity in the actual motion. Is that something the court needs for ECF separately?
I would file it separately.
Okay.
I would file it separately because that way, a lot of times when I hear that a emergency motion has been filed, I go to the certificate of emergency right away to see what it is, why it needs to be handled and when it needs to be handled by. So I would definitely take care of that. Okay, moving on to cash collateral motions. Cash collateral is kind of a tough concept. I think your clients will not understand it. But essentially, cash collateral is defined in Section 363 as including proceeds of property in which an entity other than the estate has a security interest. So, for example, your client might have a store, a bank or another credit lender might have a lien on inventory. The inventory is sold. It turns into accounts receivable. The lender then has a lien on accounts receivable. The accounts receivable are turned into cash, the money in a bank account. The lender then has a lien on those funds. The monies are used to buy new inventory, and the lender has a lien on the new inventory. So almost every Chapter 11 case, some don't, but almost every Chapter 11 case has a cash collateral component. A lot of debtors' attorneys who are filing Chapter 11s for individuals are, let's say, individuals who have rental properties. They're not looking at the mortgages to see if they have an assignment of rents provision, to see if the lender has a security interest in the rents. They're not seeking the use of cash collaterals or seeking court authorization. So you definitely want to take a look at that, because you don't want to find yourself in a situation where the lender comes screaming in, wants to get an order prohibiting the use of cash collateral. If that happens, it's going to shut your debtor down. So you need to take a look at that for sure. Rule 4001B2 says that a final hearing on a motion to use cash collateral can't be heard earlier than 14 days after the motion is served. So that means that your emergency hearing is always going to be on an interim basis. So your emergency hearing's on an interim basis. It'll then get continued for a final hearing. In your motion, you need to identify the secured creditor who has a security interest in the cash collateral. I see cash collateral motions all the time, and I don't even know who they're directed to. So you need to identify that. You need to make your proposal for adequate protection. Typically, that's a replacement lien in after acquired collateral. Sometimes it includes monthly payments. For example, in a rental property situation, you might propose to make monthly payments to the mortgage company. The debtor needs to specify the amount of cash collateral the debtor wants to use and for what purposes. And again, all of this is contained in Local Rule 2081-1, so you can find that all there. But the debtor needs to say what the debtor needs the money for. And then lastly, cash flow projections. The most important part of a cash collateral motion, and I would say I see them in about half the cases. The court needs to know, creditors need to know what those cash flow projections are on an emergency basis. How long those projections go out depends, at least for the first month of the case, possibly for the first 3 months of the case. If you have a client whose business is seasonal and they're going to earn all their money between December and April, and you're filing your bankruptcy in August and you're going to run at a deficit, you want to show that it's going to turn around over the course of a year. Because if a debtor comes in with cash flow projections showing that the debtor is operating at a deficit, that is not going to fly well, go over well with the creditor or with the court. If everybody understands that it's a seasonal business, I had a hotel case once where it was a seasonal business and the projections showed, we're in the whole $20,000 a month, $20,000 a month, $20,000 a month, then we're, in the black, $50,000 a month, during the season. That's something that creditors usually understand and the court usually understands. But when you make those projections, they have to be based on something. And usually when a creditor comes in on a cash collateral motion, usually that creditor knows the alternative is closing the business down. And usually the creditor doesn't want to close the business down. But, you can't just have your clients sit there with a sketch pad and draw out these rosy projections and next year we'll make millions of dollars, okay? If you're going to show a negative cash flow for the first couple months and ramping up then to operating in the black, maybe you want to have the historical numbers that show what the debtor has done historically. So that's something that you really need to spend some time doing. And I would suggest, unless you're in an absolute crisis situation, that before you file, you draft your cash collateral motion, you get your projections lined up. It's interesting. I had a case once. It was a disaster, filed on an emergency basis. I was the attorney. I look at the creditor's attorney in that case and just shake my head because he dragged me up to Connecticut after a blizzard to take the depositions of the primary customer of my client's business. My client didn't understand the difference between a credit and a debit. Didn't understand that deposits were not accounts receivable. Okay, I learned that lesson the hard way. You wanna talk this through with your client's bookkeeper, your client's accountant. So cash collateral motion's often the most important motion that you can file in a Chapter 11, and you need to get off to on the right foot right away. Okay, pre-petition wages. Sometimes you have a client that isn't short on cash, and man, if they can pay their employees through the date of the petition, great. If they can't, most businesses, people think they hold back wages. They're not holding back, but the pay period ends on Friday, and then the employees get paid the following Friday because they have to have time to process the payroll. If your petition date interrupts that cycle so that a portion of the next regular payday is going to include post-petition wages, then you want to file, is going to include pre-petition wages, then you want to file a motion for authority to pay the pre-petition wages. The post-petition wages themselves can be paid without a court order, but you do need court approval to pay the pre-petition wages. You need to specify the employee, the amount of the wages that are due, whatever their withholdings are, because usually, there's benefits and Social Security contributions, so the net wages aren't enough. You've got to be able to pay the gross wages. And courts will usually authorize the payment of pre-petition wages up to $11,725, which is the priority amount that's authorized by the Bankruptcy Code. So that's usually not a problem. Sometimes for insiders, court will say, no, I'm not going to authorize the payment of pre-petition wages to insiders on an emergency basis, but down the road the court may be willing to do that. Critical vendors, something we don't see very often. So first question, what is a critical vendor? A lot of times you have a debtor that's doing business with a supplier or a vendor, and they have a really good relationship, and the supplier or vendor says, we're not going to continue to ship to you or deliver to you unless you pay us on account of our pre-petition debt. And the debtor says, we've got to do business with these people. Well, it depends on the type of business and what those people, the vendor or the supplier, are providing. A lot of times it's just a relationship. If your company is in the retail business of selling widgets and needs a widget supplier, and there's 100 other widget suppliers out there, then the supplier that your company's been dealing with is not a critical vendor. You can work out terms with existing vendors and suppliers, COD. Sometimes they'll insist on selling COD. That's fine. You can sell COD. But you can't pay them on account of their pre-petition debt without getting an order from the court authorizing it. And a great case on this kind of started off with the Kmart case. That was one of the seminal cases in the area. But Judge Williamson, who I consider to be a natural teacher, does a wonderful job in the tropical sportswear case. The site is there, just laying out what the requirements are for a critical vendor. And I remember, I don't know if anybody here was involved in the case. I think Judge Pasquet either had this case or used to use it as an example of a critical vendor. But the story that he told was of a high-end boutique hotel in Naples that was known for its fine bedding and the wonderful sheets, and it was just incredible. And there was one French laundry in town that was capable of ironing and pressing these sheets. And the whole reason they got all these customers, you know this case, Jerry?
Absolutely.
Okay, that was a critical vendor. It was the only place locally that could prepare, could launder the bed linens in a way that would meet the expectations of this boutique hotel's clientele.
Had
So,
something like 122 count
100
Egyptian linen that
122, that's nothing. Mason
Yeah,
sells
whatever it
700,
was.
1,200 count maybe.
It was just some ridiculous number, and they were
Yeah,
the only one.
they were the only one that could do it. That's a critical vendor. But, you know, you need a food supplier, you need widgets, you can usually find somebody else that'll sell to you. Frequently COD, okay? But, you know, they're not usually gonna meet the critical vendor test, and I've never had to deal with this issue. The really important factor is this third factor, disfavored creditors. Those are the creditors who are not critical vendors, or at least as well off as they would have been absent a critical vendor order. You've really got to be able to predict what the distribution to unsecured creditors is going to be, and show that the creditors who are not critical vendors are not going to be treated unfairly and are going to be able to get paid. So Tropical Sportswear is a great case. You really can follow that. Okay, payment of affiliate officer's salary. What's an affiliate? That's defined in 101.2, and basically that's a person or an entity that owns more than 20% of the debtor. Usually we expand that to include insiders and family members. So when you're making a decision whether or not you want to file this motion, you really have to look critically at what the affiliate and insiders and family members are doing for the debtor. And sometimes there's duplication, sometimes they're earning salaries, but they're not really performing the services. So when you tell your client that you've got to include the name, the position, the job responsibilities, you know, sometimes that kind of eases the process. And maybe sometimes you feel obligated to file the motion and you don't know that the court's going to approve it, or creditors might be objecting to it, and you know, that's okay too. I had a case one time, bad case, ended up in a Chapter 7, and the debtor was losing money, and the attorney wasn't here in Fort Myers. The attorney comes in, he wants to get approved, $100,000 a year for the debtor's president and $100,000 a year for his wife. And the reason the wife needed money was she was pregnant. Okay. And the company was losing money. No, I did not approve that. So I never quite understood that motion. But you do need to look at it. Sometimes you'll have a family member who's in charge of marketing. Then it turns out you have a marketing director, you know, an unrelated employee that's really doing all the work. So you need to look at that closely. Okay, next is utility motions. This type of motion is frequently overlooked, and I would have to say that you overlook it at your own peril. If your client is current with utilities, you're usually not too concerned about it. But under Section 366, the utility may discontinue service if it's not provided with adequate assurance of payment within 20 days after the entry of the order for relief. So, important question to ask your clients is, are the utility payments current? Sometimes they'll say yes, sometimes they don't know. What is a utility? Electric, water, maybe internet, telephone? That's something you've really got to get the bottom of. Not to promote one particular firm over another, but I will tell you, Stichter Rydell has a great form, utility motion. Find one of their Chapter 11 cases and steal it. It's great. I did. I mean, it's a great motion. And the thing is that you have to provide them with adequate assurance. So if they already have 1 month's security deposit, you can say 1 month's security deposit provides adequate assurance. They have an opportunity to object. So the form motion, the Stichter Rydell form motion, sets up a procedure by which if they object, they contact the debtor's attorney, they see if they can work it out. If they can't work it out, then a motion is filed with the court. But it sets up a whole procedure. I have to say, I have not seen one utility motion issue since I've been practicing. I mean, the utility companies, their lobby fought long and hard for Section 366, and they've done nothing with it in my book. But it's just important that you really keep an eye on the situation with utilities. Make sure your clients are current. But finally, just get a form for your utility motion. It won't cost you anything to file it. Yes?
Going back to your statement of you've never seen utilities do anything with it. Back when I practiced in North Alabama, utility companies associated with Section 8 housing in Chapter 13 cases.
They were very concerned about adequate assurance of future
used
payment.
It a lot.
Right.
So
right.
that's some way to bring 366 and your talk today into Chapter 13.
That's a good practice pointer. But make sure your clients are current with their utilities, because if they're not, man, they got 20 days, and then the utility company can just cut off the utilities. Okay, then when you've gotten past those first day motions, and there may be a few others that you want to file, Chapter 11 debtors need to open up their debtor in possession bank account, and Mr. Wilkes is even more familiar with the logistical procedural requirements of reporting to the U.S. trustee and things of that nature. Every once in a while you'll have a debtor that has a credit card processing relationship and money is coming through a bank account, and there's no point in disrupting that bank account in order to, you don't want to disrupt the flow of money. And so what the debtor does is opens up a separate debtor in possession bank account and essentially sweeps the money that's coming in from the credit card company. The reason for the debt, one of the reasons for the debtor in possession bank account issue, and I haven't ever paid attention to this issue, but the U.S. trustee has some super guaranteed bank agreements. Those accounts are like guaranteed, far beyond the 100,000 FDIC
The
limit.
reporting
It
too.
requires
Reporting
115%.
too.
Right.
Isn't there reporting?
It's partly for reporting purposes, for us to be able to, for the United States trustee to be able to get the bank account records at any time. That's
I
one.
didn't know that.
Yes.
The second one
Yeah.
is the estate funds held in that account is guaranteed for, as Jerry McHale said, 115% of the actual amount in the account at any one time.
The bank is required to post securities as collateral
I see.
against that.
Okay, so those monies are just really
A
guaranteed.
couple of the banks have specialized offices that will do the setup, so you can do the setup through the specialized office and then go to the local branch. Local branch calls the specialized office. The local banker doesn't have to know about it. They just
Right.
talk with the people that talk bankruptcy.
I
And
see.
so it's easy.
Trustee's office does put a list of
A
what
list
banks
of
are.
approved banks, that's right, approved depositories.
Everybody in town is not on that list.
That is
Right,
correct.
and every once in a while, you'll have a debtor, especially an individual debtor, that will say, well, I have this money in a money market account, and I don't want to move it. No, money market account, very bad. Okay, securities accounts, very bad. Got to be in a debtor in possession account. You can usually get the court to approve money being passed through another account for a short period of time. But one of the most important requirements for a Chapter 11 debtor is to file those monthly operating reports. And you need to work with your clients' bookkeepers. And when I did Chapter 11 cases, I worked very closely with my clients on monthly operating reports. Make sure they make sense. Sometimes they don't make sense, and because your client doesn't understand how to prepare it. So you need to look through them yourself, and you need to work with your clients on those. We have a revision to Local Rule 2081-1 a year or so ago, I think, that requires that small business debtors file what we call the schedule of receipts and disbursements that's required in the typical Chapter 11 case and the corporate Chapter 11 cases. The small business operating reports, from my perspective, are absolutely worthless. You can't tell what's going on with them. There's just a bunch of scribbled handwriting. They're usually Xeroxed forms. They're unintelligible. And the judges decided as a group that this schedule of receipts and disbursements really gives us a picture of what's happening to the debtor from a cash flow perspective. So make sure that all of your debtors all of your small business debtors and regular corporate debtors are using the schedule of receipts and disbursements. Individual debtors have a separate form that they use, and that's usually satisfactory. But it's really important to get your client on the right track with this schedule. I had a case a long time ago, shortly after I came to Tampa, with an individual Chapter 11 debtor who was not filing his operating reports, and the U.S. trustee, Ben Lambers, kept filing a motion to dismiss, and the hearing was in front of Judge Glenn, and those of you who've appeared before Judge Glenn, you know there's no finer judge to appear before, and he is just a gentleman in every meaning of the word, and whether you win or you lose, you walk out of his courtroom and you feel really good because he listens to you, and he's just a great judge. And anyway, I knew my client was in big trouble for not doing this, and the judge was letting him live on estate assets while he was waiting for his book to be published or something. And I made a strategic decision not to bring my client to court. And it was an amazing hearing. Judge Glenn kept going, Miss Delano, I don't mean to yell at you. Miss Delano, I don't mean to yell at you. I'm like, oh, we walked out and Ben Lambert said to me, oh my God, I couldn't believe he was yelling at you like that. Never want to be in that position. Heck, get your clients to file their monthly operating reports. And not filing them would be a ground for conversion or for dismissal of the case. So, you have a client doesn't want to be in a Chapter 7, files a Chapter 11, and because they mess up and they don't get these operating reports to you, they run the risk of the cases being converted or dismissed. So that's a real problem. Okay, moving on, I want to talk about plans for a moment. You need to look at section 1123. I would strongly suggest that everyone look at official form B25A, the plan for a small business debtor, because that really lays out what needs to be in a Chapter 11 plan. That form is posted on the court's website under official forms. One of the things that the plan needs to do is it needs to classify creditors, and sometimes there seems to be some misunderstanding about that. I have seen plans where all secured creditors are lumped into the same class, or on real property where the first, second, and third mortgage is all listed in the same class. And essentially, each secured creditor has to be in its own class. Otherwise, the plan just doesn't work. Generally speaking, there are unsecured creditors. There are not different types of unsecured creditors. There are not non-dischargeable unsecured creditors. There's not guaranteed claims unsecured creditors. There's not deficiency claim unsecured creditors. They're all unsecured creditors. I'm not saying that I wouldn't allow that in a specific case. I haven't seen the case yet that I would. Pretty much they're just all unsecured creditors. Sometimes if there's an unsecured creditor, let's say that had a guarantee from a third party unrelated to the debtor, and that unsecured creditor was going to be paid in full by the third party, you might classify them separately and provide that they don't receive distribution through the plan or something like that. But generally speaking, all unsecured creditors are the same. It doesn't make any difference how they arose. Your plan also has to specify the treatment of each class. And one thing that I see some confusion on, not by anybody in this room, but I see some confusion. People don't understand what an impaired class is and what an unimpaired class is. And section 1124 defines impaired and unimpaired and says, a class of creditors is impaired unless it leaves unaltered the legal, equitable, and contractual rights to which the claim or interest entitles the holder of the claim or interest. So if you do anything, if you are curing arrearages over time, impaired. If you are surrendering collateral in full satisfaction of the secured debt, impaired. The only time it's not impaired, sort of think about it like a Chapter 13. You're paying direct outside the plan. It's not in default. You're just going to make the regular mortgage payments. You're just going to make the regular lease payments. You're just going to make, the regular installment payments as they become due. Basically, anytime you do anything to affect that debtor-creditor relationship, you are impairing the treatment of that creditor. So be careful and take a look for that. The plan also has to specify the means for the plan's implementation. And sometimes plans are pretty inadequate on that. I had a plan once where the plan says the debtor's going to fund the plan through future income. The plan provided to pay $36,000 to unsecured creditor. The debtor had $125 a month available looking at IMJ. Well, the debtor was really selling a bunch of non-exempt assets and using that to fund the plan. So the plan has to make that clear, because I like to think that I have a pretty good memory and I can remember what was going on from the case management summary and what happened at the first status conference and the various cash collateral motions. But I like to know what's going on, and I think that the world out there, creditors who are getting this in the mail, they're not living in Chapter 11 land like the rest of us are. They don't see how all these things fit together. So you've got to spell this out for them. Now, when you file your plan, you're also going to file a disclosure statement. The disclosure statement has to contain adequate information to enable a creditor to vote on the plan. The disclosure statement should include pre-petition, some mention of pre-petition financial performance. That's usually blended in with the reasons for filing the Chapter 11 bankruptcy. Post-petition financial performance. Now, what I see some attorneys do, and I saw one recently, not anybody here, very good firm though, I'm kind of surprised, attached 150 pages of monthly operating reports. Do not attach monthly operating reports to show your client's post-petition financial performance. First of all, it's a cash flow picture. That's all it shows is what's happened as far as from a cash perspective. Secondly, it's too much information, and people that aren't used to reading monthly operating reports don't even understand what's in them. You can summarize what the post-petition operations have been. You can just summarize month by month income and expenses by various categories of expenses. So you need to generally show that there's been some improvement in the debtor's financial performance, or there's some reason why improvement is expected to come in the future. But just to attach, 4 or 5, 6 months worth of monthly operating reports really is not going to cut it. Your disclosure statement needs to set forth the reasons for filing Chapter 11. That's pretty easy. The steps taken by the debtor to facilitate reorganization. That's like my bundt cake factory that I was talking about before. We closed the plant. We're surrendering this property. We've sold these assets. We've fired the thieving bookkeeper. What have you done to solve your problem? Most importantly, projections reflecting how the plan will be feasibly consummated. What I see happening frequently is attorneys that do not include, let's say, individual debtors with a bunch of rental properties, but they don't include any of the debtor's personal living expenses. So you can't tell, is the debtor going to have money left over at the end of the month to fund a plan? I see frequently rental properties just kind of lumped all together. You really have to go property by property, because it may be that some properties should be surrendered. Some property, most of the time, what we're seeing now, and hopefully it'll be turned around in years in the future, but right now what we're seeing is properties with no equity. And so the debtors have successfully either stripped off or stripped down the mortgages, but the properties are fully encumbered. And the question is, as fully encumbered, are those properties cash flowing in a way that it makes sense to keep them? So if you have a property that's running at a deficit of $300 or $400 or $500 a month, the debtor's got to make a hard decision whether it makes sense to keep that property. And sometimes it does. Sometimes that's a short-term deficit because it's a duplex and only half of it's rented out, and another tenant's going to be coming in soon. Sometimes there's an important reason for holding on to a property until the market turns around. But I really think that until you have done that property by property analysis with your client doesn't understand what's in the best interest for the client. So that's really important. The plan also has to include a liquidation analysis. The reason why that is important is because under Section 1129A7, each class that does not accept the plan has to receive at least as much as they would receive in a Chapter 7 case. So creditors need to be able to see, and this is your chance to sell your plan too. If the liquidation value is nothing, and the plan is providing for a 10% distribution or a distribution of $50,000 to unsecured creditors, your unsecured creditors are better off taking the plan than they are receiving nothing in a Chapter 7 liquidation. So that liquidation analysis is very important. And if the liquidation analysis is that there's $25,000 or $30,000 or $50,000 in liquidation value, you need to take that into consideration when you're drafting your plan. You all, I think, are familiar with our conditional approval process. So if the disclosure statement has all of this information in it, I typically will conditionally approve the disclosure statement, then set a combined hearing for final approval of the disclosure statement with plan confirmation. To those of you who represent creditors, I think I've seen maybe 1 or 2 meaningful objections to a disclosure statement. Usually they're confirmation issues, and that's why it makes the most sense to combine those 2 hearings. Yes, Mr. Wallace.
On disclosure statements, you may also want to look at official form 25B, which is a small business disclosure statement. It lays it out, basically what you're seeing there, but it gives you a roadmap.
Right. And the other thing I neglected was tax consequences. We had, the Tampa Bay Bankruptcy Bar Association last week had an accountant, you don't want to see it, because he was discussing tax consequences. Were you there, Scott?
I was.
Nobody understood it. It was like, oh my gosh, this is why we say, you must see your tax advisor. It was at a level that was way up there. So just remember, just remember, you tell your clients, you must see your tax advisor. But he sort of demonstrated that not all tax advisors are created equal.
I think I received 3
Because he
texts.
comes in and cleans up other people's accounting work, but, you know, tax consequences to the debtor, he wasn't talking about to the creditors, but, you know, to the debtor, like it might affect the basis of the property, and, you know, we're also worried, I'll just mention this for a moment, not that I completely understand it, but we're also worried about the recognition of COD, what was that? COD stands for forgiveness of debt, but COD stands for something. I'm forgetting what. Cancellation of debt. Okay, so we're all worried about that being a tax consequence. But basically, on a piece of real property, let's say that's underwater, and then there was a forgiveness of debt, we're all worried. Oh, there's a forgiveness of debt, but he says no. It's really two separate events. One is the sale. One is let's say you're surrendered it back to the lender, and the lender's then forgiving the balance. One is the sale, and your client might have loss on the sale. Okay, this wouldn't apply to principal residences generally, but let's say your client bought a commercial piece of property for $400,000, and now it's paid $200,000 for it. Excuse me, now it's sold it for $200,000. Your client would have a loss of $200,000 on that sale. Then your client might have a forgiveness of debt for $200,000. They might cross each other out. Anyway, all the more reason to refer everyone to tax counsel. And that's usually, you know, there's that provision in the code, you have to spell out the tax consequences. You don't know what they are. You just want to advise creditors, they need to see their own tax advisor, right?
Look at official form 25B.
And what does it say?
It gives you a little bit of a snippet of what a tax consequence would look like. It's very short, very sweet. If you know more about, as Judge Delano was saying, then you'll want to flesh it out more in the tax consequences. But
You don't have an attorney-client relationship with those creditors.
Right.
You don't need to be giving them any legal advice.
1368 and 69 Internal Revenue Code, unfathomable to me. I
Yeah,
tried to
yeah,
understand
yeah.
it.
Yeah, this was a frightening presentation because nobody really understood what he was talking about. And he seemed to, so that was good. Anyway, so that's basically it for, another moment on projections. I want to see that the projections demonstrate that the plan is feasible, okay? And I want to see them for the duration of the plan. So if you've got a 5-year plan, you need to lay out those projections. And you can say, you know, let's say you have a wage earner, you know, doctor or somebody, and he's, you know, making a great salary. You don't expect his income to increase. Well, then you can say that in the disclosure statement. You don't expect his income to increase. But you need to basically provide the projections during the period of the plan. And a lot of times, plan payments, they step up gradually. So you want to show that, you know, this is what the cash flow projections are this year, and we're going to make quarterly payments based on these projections. Next year, we're anticipating a 5% increase, and so, you know, we're going to have a better bottom line, and we're going to be able to make additional payments. So you definitely want to include that information. Okay, on to confirmation. Confirmation affidavit, that is a requirement. I think it needs to be filed at 96 hours.
96 hours.
Okay. Generally speaking, if you can, we do our Chapter 11s on Wednesday. Get them filed by Monday. As long as they're filed by Monday. It is hard for me. I don't know if I have the lawyer here in the room. I don't think so. Yes, I look at my cases the day before. I frequently look at them the week before. My staff sends me an email to tell me what's recently been filed. 1:29 a.m., the morning of the confirmation hearing. I am not going to have read that one. So anyway, you want to file that confirmation affidavit. And what it does is it establishes an evidentiary record that all of the requirements of Section 1129 have been satisfied. So basically, you just need to walk through all the requirements of 1129, just one by one. Have your client state affirmatively that these requirements have been satisfied. Ballot tabulation, I think you're all familiar with that. I have not followed, I know the CMECF system has a way of tabulating ballots now. I have to admit I have not taken a look at it. But there is one thing you could do with ballot tabulations that would help me immensely. If you would do your ballot tabulation and under each class, just give me in as short a sentence as possible what the treatment of that class is. Because that's what I do. I take the ballot tabulation and I take the plan, and then I go try to figure out what the treatment of all the classes are. So if, for example, your treatment is to surrender in full satisfaction of the debt and you didn't get a vote, well, that's helpful for me to know. So just whatever the treatment is, cure arrears, modified or, pay the secured portion of the claim with interest at a certain amount. Just something like a little cheat sheet. It would be helpful for you too, because it would be helpful for you to determine whether you had the vote of all classes necessary to confirm the plan. Sometimes I get a ballot tabulation and it only, let's say maybe there's 26 classes of creditors, but only 4 classes voted. So I get a ballot tabulation for those 4. Well, I have to go back to the, drawing board and figure out what's going on. So that would be a huge help. Let's see. Under 1129, each impaired class of creditors has to accept the plan under 1129A8 or must be subject to cram down under 1129B. Now, 1129B, I think, is a very difficult section of the code to follow. It's just a lot of words, very difficult. But in most of your cases, what 1129B is going to say is that the court can confirm a plan even if a class does not accept, as long as the plan does not discriminate unfairly and is fair and equitable with respect to each class which has not accepted the plan. So fair and equitable is defined. And essentially, this is a very simplistic way of looking at it. Fair and equitable as to a secured creditor means that the secured creditor retains its lien and receives payments equal to the value of its claim. So that means if it's a piece of real property, the creditor's owed $300,000, the property's been valued at $200,000. As long as the creditor is being paid $200,000 with interest over time, that creditor is receiving payments equal to the value of its claim. You might have a fight over the value of the claim, but that creditor would meet or the treatment of that creditor would meet the standard necessary for cram down. The other possibility with respect to a secured creditor is that it received the indubitable equivalent of its claim. To me, the perfect example of that is surrendered property. If the property's been valued at $200,000, you're giving it back in full satisfaction of the secured debt, the creditor is getting the indubitable equivalent of its secured claim. So that would meet the cram down standard. So some attorneys would say that claim was, or that class, which would only be that claim, is unimpaired. I would say it's impaired, but it satisfies the cram down standard if it's not, if that creditor hasn't accepted the plan. With respect to unsecured creditors, and this is simplistic, fair and equitable essentially means that the unsecured creditors receive property, but that's money in most cases, equal to the amount of the claim, or no junior class may receive or retain property on account of their claims or interests. And that means that either you're paying unsecured creditors in full, or anyone that's junior to unsecured creditors isn't receiving or retaining anything. Who's junior to unsecured creditors? Equity, okay? And I will tell you, my favorite teacher, Judge Williamson, has a great case, just came out recently. It is the Martin case, 2003 Westlaw, 2013 Westlaw, 5229816, and it just came out September 17th. And it's dealing with the absolute priority rule, which is what I've just talked about is the absolute priority rule. It deals with the absolute priority rule in the context of an individual debtor. Essentially, what the case holds is that following enactment of BAPSIPA, the absolute priority rule applies in Chapter 11 cases except with respect to the debtor's post-petition earnings. And the debtor may not keep any estate property other than exempt property that the debtor owned on the petition date and confirm the plan over the objection of an impaired class of unsecured creditors. Judge Williamson had asked me to spend a few minutes editing this decision, so I worked on it a little bit, and I'm happy to say that after I've worked on it, I understood the issue of the absolute priority rule with unsecured creditors. This is consistent with Judge Jenneman's ruling in, I forget the name of it, Gellin, and it distinguishes Judge Buckley, who had a little dicta on the subject in, was it in Safety Harbor or one of those cases? One of Judge Williamson's cases. Anyway, he does a very tactful job of distinguishing Judge Jenneman's statements on the absolute priority rule that were dicta and didn't quite apply given the facts of that particular case. So I would definitely recommend that case to you. Okay, discharge. When you have a Chapter 11 individual debtor under the BAP-CEPA changes, the debtor doesn't get a discharge until the completion of all plan payments. Most of you want to administratively close that case, and I think you've probably seen that I'm a bear on that issue and pushing these cases through status conferences, post-confirmation status conferences to get them closed, because although the U.S. Trustee's Office would like to collect those fees, I don't want them to. I want your debtor not to have that burden, because as long as they're having to do disbursement reports and pay quarterly fees, there is something left for them to mess up on. You don't want that to happen. You want to get that case administratively closed as soon as possible. So there's a form motion. It's on the court's website to move to administratively close the case. That's on negative notice if we don't hear from the U.S. Trustee's Office or creditors. Creditors have never responded to that. Maybe in one or two cases where the debtor was a little bit behind on payments, but by and large, I get no response. Then the case will be administratively closed. And I have walked through several times, and I think I finally have it down pat, because the judges, we meet, we agree on a procedure, and then we can't remember why we did it, or what the procedure was, and I make Mr. Wilkes and Ms. Cindy Burnett come to hearings and explain it to me over again. But anyway, when your debtor has finished making all of his payments, then you want to file a motion to reopen the case and have the discharge entered. On the court's website, there is a form motion to reopen. You submit that form motion to reopen. You submit it with an order granting the motion. The order granting the motion will be entered right away without a hearing, and that order gives creditors 21 days to object. So that just should be an automatic process, and then the U.S. trustee, if they have an issue, they will come forward. But that should work out pretty smoothly. We've had a few cases now doing that. Their cases are just starting to close out. Yes?
Please schedule filing that motion in accordance with where you are in the quarter, so that you can get this resolved in one quarter, not two.
Yes, you want this resolved in one quarter, because you don't want, you're going to be responsible for a minimum fee, right? During the quarter in which the case is reopened.
How much the distributions are, but yeah, at least the minimum.
Right, you want to get this done, but you don't want to file it on, March 20th and then go into the second quarter. So that is very good practical advice. So I think that process is working pretty smoothly right now. And then final degree in non-individual cases, you file your certificate of substantial consummation. You file a motion for entry of final decree. We have come to an agreement with the U.S. Trustee's Office that although that motion for entry of final decree does not need to be served on negative notice, the court is going to sit on it for 14 days. And if we hear something from the U.S. Trustee's Office, we'll set it for hearing. If we don't hear from them, then we'll go ahead and enter the final decree. So just know that we're holding those for 14 days. There may be specific cases that you're coming up on the end of a quarter. If that's the case, you want to contact us and contact the U.S. Trustee's Office, and if we get confirmation from the U.S. Trustee's Office that we're okay to enter the final decree, we won't wait the 14 days. So that's usually, usually I have a status conference as close to the end of the quarter as I can in a case that's still open, and my law clerk and chambers are in constant communication with the U.S. Trustee's Office. But don't count on that, because it may slip through our cracks, because it's not really our priority. I mean, we want the cases closed, but it's your priority to get that taken care of. So you need to be reminding us. You can't just count on the fact that you filed a motion for entry of final decree on March 28th, and that the judge's law clerk is going to contact Mr. Wilkes and see if it's okay to enter the final decree. You can't count on that. You need to be in touch with us and make sure that that's getting taken care of. And I think, in a nutshell, that's Chapter 11. So, I've run a little over. Anybody have any questions? All right, you know everything. Just work on those projections. All right, thank you.
Thank you.
One final thing, I know some people had some suggestions for other courses, and we talked about it at the dinner. A little scatterbrain that night. So if you do have other suggestions for upcoming courses that we can do in meetings, just email me, and we'll get together about arranging it. Thank you.